joining me now is Singhvi, Member of Parliament for the Rajya Sabha and Senior Advocate of the Supreme Court. It's been a busy day yesterday and today with a whole host of verdicts coming out. And Singhvi, good evening to you. Let's begin with Sabarimala. That was a debate that we were just having. It's a tricky one, what the Supreme Court is intending to do right now, Mr. Singhvi, to say that we are going to club all of these issues together and then perhaps come with one clear judicial policy. How do you decide to what extent should there be judicial intervention when it comes to matters of faith and belief?
Before I answer the specifics in your question, let me start by saying and also disclosing that of the 4 judgments since yesterday, I've been actively a part of 3 as the lead senior counsel. I was the lead senior counsel in the first Sabarimala. I was also the lead senior counsel in the review petition decided today. I also happened to be appearing for the Speaker whose order was upheld yesterday in Karnataka. And thirdly, the third out of the 4th is the Rahul Gandhi's contempt petition. So you may discount my views as a counsel appearing, or you may give more premium to my views as somebody who's a little knowledgeable with these 3 cases.
Right.
Secondly, your specific question on Sabarimala. Well, I think there is in the sense of a legal victory, there is a partial victory for us, because the first judgment of Sabarimala, very patiently and comprehensively heard, we lost by 4-1 on the basis that women cannot be prevented on the conditions which Lord Ayyappa's temple imposes. And that was the ruling of that bench on a 4-1 split. Today's majority verdict, in effect, puts that judgment under a cloud, because it says a larger bench, which means larger than 5 judges, which is what the earlier bench was, will review this. Review can go either way. It doesn't mean it's been nullified. It doesn't mean it's been cancelled. But it has certainly been put back on a reopened plate. So the earlier judgment is in a cloud. That's point 1, and therefore there is a victory in that sense for our side, for our contentions. Remember, by the way, that I appeared for, I forgot to mention the most important thing, I appeared for the Devasthanam board.
Yes.
Which means that the board was arguing that the Ayyappa traditions of not allowing women between a menstruating cycle of ages do not allow them to enter. So that stand has been partially vindicated. However, it is certainly not clear yet, because the judgment is open. A 7 or a 9 judge bench will decide this in the future. Thirdly, an interesting, delicious question is not clearly addressed. Namely, while the larger bench of 7 or 9 judges is constituted, which will take obviously a few months, and hears and decides, which may take even years, till such time is the first judgment of Sabarimala operative or not? Now, my legal answer to that is yes, it is operative, because there is nothing in the judgment, I find, which stays the operation, or in other words, the implementation of the first Sabarimala, which means that the first Sabarimala is liable to be implemented. Of course, the dissent by Justice Nariman and Justice Chandrachud is equally, although against me, clearly powerful, evocative, very well drafted, and very, very eloquent and poetic language used. So under that, of course, it should be implemented immediately. Now, on the normal principle that in the last 1 year, that judgment has not really been implemented on the basis that today's review petition was pending. On that parity of reasoning, I don't know what's going to happen, because there is, on the one hand, no stay of the first Sabarimala. On the other hand, there is no final decision on the review, which is yet to be heard by a larger bench. Well, there's going to be some political controversy that legally I believe it should be implemented, although I'm arguing the opposite. But politically, people will say, don't implement till you decide the review. Thirdly, I think the legal issues are very delicate and must be understood very briefly by our viewers. The legal issues are not as simple as they sound. I also happen to be, by the way, the counsel in the Dawoodi Bohra matter for the Dawoodi Bohra community. Now, these are matters of Article 25 and 26 of the Constitution, which guarantees that your, mine and everybody else's belief, faith and right is a constitutional fundamental right so long as it is an essential part of the religion to which you belong. The crucial question is every ritual, every form, every practice an essential part of that religion?
Right.
Now, in the case of Sabarimala, we were at pains to point out that the Lord Ayappa deity is a unique deity which is worshipped in a celibate form and intrinsic and attached and inalienable and inextricable to the very nature of the deity is its celibate character. And that is why from there flows the oddity of women in a menstruating cycle being excluded. It is like saying that you recast or redefine the deity you are worshipping, that you go and worship a Shiva, but because Shiva has certain prohibitions attached to him, you start treating him as non-Shiva or somebody else. Well, according to me, worshippers cannot forget the intrinsic nature of Ayappa. Now, if that is correct, if it is found by the court, it becomes an essential part of Article 25 and 26, which is that denomination known as Ayappans genuinely bona fide hold a belief about the essential thing. And I think that's a very important question of law.
Then I'm very curious, Mr. Singhvi, what is the argument when it comes to female genital mutilation, within the Bora community, since you said you're also, linked to that case?
Now this is the problem. Now this is another interesting issue you've raised. Again, I'm the counsel, so please discount or please give a premium as you might like. I'm the counsel, by the way, for the Dawoodi Bohra community. Now, the first point we made there is rather interesting. Words have an emotive penumbra. If I use a word, it immediately conjures, the words have a meaning of their own. The very word conjures up an image. When I say FGM, female genital mutilation, what is immediately conjured up in your mind are mutilation practices. Whereas the Dawoodi's whole case is that there is no such thing happening. FGM is a word taken from African tribal practices. That's the interesting point. Tribal practices in parts of Africa are obscene, are cannibalistic, are violent, and are absolutely disgusting. And one of them is FGM, which is to mutilate the female genitalia to prevent, in most cases that's the rationale, the very possibility of pleasure which females are supposed to be denied of. Now that's a tribal practice of Africa. In the case of Dawoodi Bohras, nothing of that happens. They are at pains to point out in writing briefs we have given that there is no mutilation. It's the most prosperous community in India, one of the most prosperous. It's a minority here. It's one of the most advanced, prosperous, progressive communities amongst Muslims. They do it as a rite of purification, pretty much like a male circumcision, which happens for almost all male Muslims. It's a small nick on what is known as the prepuce of the clitoris, and it is supposed to be a purificatory rite. The Dawoodi Bohras are the strongest supporter of that, and the women in that community, numbering lakhs, are the strongest supporter of that, because it is done painlessly, without infection, without mutilation, nothing of the sort. Unfortunately, a small group has given the impression that African cannibalistic, tribal, violent practices are being done by the Dawoodi Bohras. For the Dawoodis, this is one of the 7 pillars of their religion. I don't go into details, but in Islam there are 7, 2 or 3 are optional, 5 are compulsory. In the Dawoodi Bohra subsect and a few other subsects, all 7 are compulsory. One of the 7 is this purificatory rite.
Okay.
It's just a nick at a particular age, much lesser than when you circumcise a male. Now, nobody suggests that male circumcision is to be stopped.
Maybe if men want to take up that issue at some point, they will be free to. But of course, I hope to have a deeper debate on this with you or some other day, Mr. Singhvi. But let me ask you this question:
all across the Islamic world.
The thought of combining all of these issues together, whether it's female genital mutilation in the Bori community, or whether it's the issue of allowing women in specific dargahs or mosques, or whether it's the issue of allowing Parsi women who've married outside the community access to their own religious temple and holy temple. Can there be one answer to all of these issues, which for each religion or each sect is a very different but a very, very important issue? Can we really combine all of them?
Well, I must frankly concede that I agree with you, even though it's a point against me which you are making. I think on this front, the learned judges in the majority, which have partly or largely held in my favor, can possibly be faulted because they've expanded the universe of matters which you are rightly saying can be very radically different. The legal considerations by which you will test whether a nick on the prepuce of the clitoris is an essential part of the Dawoodi denomination belief are quite different tests and considerations than that by which you will test the Sabarimala ethic. But more than that, both of these would be very different from a vast array of other practices like, for example, women being allowed inside or not. General legal principles may be the same, but you can't aggregate cases which are contextually so radically different. And there I think the majority may have bitten off more than it can chew, because the majority is aggregating they've given 4 or 5 examples. For example, even the exclusion of a non-Parsi from a Parsi Agyari. It is true that they raise the common issue of Articles 25 and 26. It is true the legal provision is the same. But that doesn't mean that every 25-26 case can be aggregated and heard by the same bench at the same time. The tests of whether a exclusion of a non-Parsi from the Agyari is an essential part of religion versus a test for this purificatory rite by the Dawoodis versus a test for Sabarimala will be totally radically different in the contextual factual sense, although legally Article 25 is common to them all. And I think here ultimately, my own feeling is, as and when this larger bench sits, they will have to take each case separately, one after the other, even if they are taken up in the same bench.
Okay.
So you'll have to hear first the Agyari matters, second the Sabarimala matters, third the Dawoodi Bohras matters, etc., etc. You can't kind of have a common, hearing and approach on the factual and contextual differences.
Well, that's going to be very, very interesting. Now, if I can just move on to the other big case where the verdict was delivered today. And Mr. Singhvi, we heard you and we played out your comment when it came to the to Rahul Gandhi contempt plea decision. But I wanted a response from you on the overall Rafale verdict that has been given today, essentially because the entire campaign strategy of Congress party for general elections was based on this one big issue. It was one of the biggest issues that Rahul Gandhi repeatedly spoke about, and today the Supreme Court seems to have said there is no merit in these charges.
I think that's a misapprehension and misunderstanding entirely of what the Supreme Court was and what the Supreme Court has said. Now I take it we're not talking of Rahul Gandhi's contempt matter where I appeared. You made that clear, so I'm not talking about it. You are talking of the main Rafale judgment. What the court has done is, A, it has corrected the mistakes which crept into its first judgment, which were mistakes sought to be corrected by an application by the Government of India. So that's one thing. The Government of India accepts that there are mistakes in the judgment and they say, please correct it. They do correct it. The second is they say that this court in Article 32, now Article 32 means it's a direct petition to the Supreme Court, is not the appropriate court to decide whether there is culpability or not, whether there should be a FIR or not, whether there should be a charge sheet or not, whether you, Tanvi Shukla, is to be arrested or not, etc., etc. They say this is all a mega proceeding. It is not maintainable in that level, and we find nothing here which requires us to interfere. And in the review, they say we reiterate the earlier order as far as this part is concerned. So to that extent, you are right. There is a perception that those who wanted prosecution initiated by the Supreme Court, they have not succeeded. But that's not the story at all. There are two nuances which are being missed out. A, the third judge today who gave a concurring judgment. Now, concurrence means the result is the same as the main, but the reasoning is added.
Yes.
So it can't be called a dissent. It can't be ignored. The third judge clearly says that such matters will not lie at the mega level of the Supreme Court. But it doesn't mean they won't lie at all. Suppose I file a complaint to a CBI or I file a complaint to the relevant police force that Tanvi Shukla is guilty of so-and-so, please investigate her. Well, that proceeding will be open as per the third judge for that police authority, be it the Delhi police or the CBI, to possibly, depending on the facts, register an FIR against you and possibly thereafter to investigate. Now, that part is specifically kept open, of course, by 1 out of 3 judges. But that's not a dissent. Secondly, even dehors the third judge. I'm asking myself, the Supreme Court is limited only to the mega issue, saying that this is not appropriate proceedings to interfere. But today, if some vigorous citizen who expected fair play was to approach a prosecuting agency and say, look, I have this material, please look whether you will register a FIR, investigate. In law, it is open. It is a different matter that we believe that the government of the day is so overpowering that no police official, no police station, no thana can dare to register a case.
Okay, but Mr.
Certainly,
Singhvi,
in theory, it is open.
I'm
And
just
I have no
wondering,
doubt that taking the cue from the third judgment, people will open that door and will follow that path.
but I'm just wondering, Mr. Singhvi, you know, because there was so much of documentary evidence available, leaked or not, or, you know, access whichever way, but out in the public domain at one point of time, and with the Supreme Court did have the option, could have ordered for an investigation.
I agree with you, could have is right. But normally, the Supreme Court does not act at the macro mega level on such issues. There is a magistrate's court, there is a district sessions judge, there is a high court. Normally, the overwhelming bulk of cases, they say go there first. And that's about all that has happened. Please do not call it a clean chit.
Yeah.
There is clean chit means that we examine the evidence and find nothing culpable. Yes, equally, it's not a culpability chit. They don't say we find something culpable. Not at all. They only say that it is not our forum which will investigate into it or direct an FIR. Certainly not over. If and when there is an independent prosecuting agency, they can look into it.
Okay, before I let you go, Mr. Singhvi, my next conversation refers and is about Karnataka and the disqualified MLAs who've now tonight been given BJP ticket for the by-polls. So the larger question we are asking is, do we need a new law, some kind of a stronger deterrent for these turncoat netas, because you may get disqualified, but if 3 months later you're able to fight in the by-polls and come back to power, then what's really stopping people from jumping ship and what's really going to stop horse trading?
Very good question. I largely agree with your sentiment, but let me explain very quickly in the limited time available. Firstly, I happened to appear for the speaker in the earlier proceeding, and each of my points was vindicated except one. Now, disqualification upheld, resignation not an answer, and less than 7 days also, it's possible for the speaker to give. However, and I must confess that that was not my advice, in fact, it is against my advice. The speaker has added a paragraph saying that having disqualified you, which is upheld, having not accepted resignation, which is also upheld, I now say that you can't stand for elections till XYZ years. Now, as the law today stands, that part of the speaker's order is incorrect. And I think the Supreme Court is right. The Supreme Court has rightly only held against the speaker on that limited paragraph. However, I entirely agree with you that if a message is to be sent that you can't get the benefits and fruits of your own defection so quickly, that is to be done, then yes, the law should be amended and will have to be amended. You see, what is happening in practice is that I use all kinds of enticements and allurements, especially if I am a very powerful or resourceful person, to get you to defect. Now, it is true that defection is because you have entered parliament or assembly on somebody else's ticket and you defect to me, so there is a change and it is punished by disqualification. But when you again present yourself to the electorate, there is no bar, because you are in a sense starting on a clean slate, and that is why there is no bar. The law should be amended to say that at least once you are found guilty of disqualification, for X period, you should not be allowed to stand again. It's pretty much like what you already have in the Representation of People's Act for what is known as the corrupt practice. Suppose you win an election against me and later on I file an election petition against you and prove that you indulge in a corrupt practice. For example, bribing somebody, or getting votes on the grounds of religion, or a communal speech. Well, if corrupt practice is found in a bilateral matter, that is me versus you, then you, the candidate who has won by corrupt practice, if it is so found by the election petition court, will be disqualified for 6 years. That's a provision. But that doesn't apply to 10th schedule. And that's why a provision similar to that, although I would not say 6 years, I would say let there be a cooling off period, that once you are found disqualification guilty, don't be allowed to stand for 1 year.
Yeah.
Don't be allowed to stand for 18 months. so that people will know that if you play over adventurism with 10th schedule, even though the people who have lured you, and mark my words carefully, Tanvi,
Yes.
the people who have lured you with we know what kind of inducements,
Yes.
even they cannot get you back by those inducements with all the money, power, etc. of the state by simply a by-election held 3 months later. Because remember, the by-election is the inevitable consequence of your own defection.
Correct.
I defect to you.
Correct.
That seat has to become vacant. By-election is held, I get elected again. So therefore, this is a part of the law which needs to be looked at. But today, the Supreme Court is right. I can't say my client, the Speaker, was right. He was upheld on all other fronts. But at this point, today as the law stands, there is a lacuna.
Today, as the law stands, the Speaker doesn't have the right to bar anybody from contesting polls, and which is what the Supreme Court said. But should there be a law for some kind of a punishment, 1-year term or 5 years is the big question. Thank you for setting the stage for our next conversation as well. Abhishek Manu Singhvi, we appreciate you joining us here on Mirror Now.